The appellant's closing submission, so I'm not going to read them all because it's very lengthy, and I did say we'd try and finish by 1 o'clock to give you a reasonable opportunity. I'm not in the same position because I don't think he gets to reply to me. I am going to spend a little bit of time just with some observations on both of the opposing closing submissions. I'm not going to go through them paragraph. So what I'll do is a bit of reading and a bit of responding, and we'll be done in an hour's time.
Thank you.
The appeal concerns an application for planning permission for construction of 55 affordable dwellings. In addition to dwellings, the proposal includes the provision of open space, landscaping, sustainable drainage, highway works and other related works. The proposals were refused by the Planning Committee at Chelmsford City Council, despite a recommendation of approval from the local planning authority's planning officer having considered the proposal over a 54-page report. There were 5 reasons for refusal in summary, and the issues raised were impact on the Green Wedge, harm to designated heritage assets, harm to trees within the conservation area, non-compliance with design and placemaking standards of the local plan, and lack of a Section 106 agreement to secure the infrastructure required. In addition to the above, the custodians of the Chelmsford Valley Water Meadow, who are the Rule 6 party, have raised the following further issues: flood risk, highway safety, and the offer of transfer of land for the provision of public open space. This closing statement follows the order of issues as they were dealt with in the inquiry. Heritage, the appellant does not seek to argue the proposal will not cause any harm to any heritage assets. To take that position would be plainly unreasonable given the location of this proposal. The question has always been what the level of harm will be, which assets will be affected, and whether those harms are trumped by the public benefits of the proposal. Heritage assessments are conducted by following historic England's methodology for assessing harms, and this exercise is carried out by experts who study and train in this area. The reason why such strict methodologies are adopted is to ensure that decision makers can rely on an objective methodology and mechanism to produce results, so that competing conclusions, if there are any, can be fairly assessed. All parties, of course, have the right to give their opinion on a proposal. However, there must be a difference in weight that is afforded to an assessment of harms which flows from a recognised methodology and what an expert who is trained, literally, in heritage assessments may say the harms are. Mr. Ford, by his own admission, remarked that he does not follow that statutory approach. Presumably, he was referring to the historic England guidance. Therefore, before delving into the actual assessment of harms, we ask you to bear in mind this crucial difference in the evidence produced by heritage experts such as Mr. Stoughton and Mr. Curran and Mr. Ford. As was pointed out in the case of the Icarian Reefer, experts should notify the tribunal when an area falls outside their expertise, and perhaps even more importantly, where a person presents themselves as an expert, their overriding duty is to the tribunal, and they should not act as an advocate. Assessment of harms. Turning then to the harms, the NPPF advocates for an asset-based approach when assessing heritage harms. In this case, 5 listed buildings were originally identified as those which could be affected by the proposal. In addition, the appeal site is also within the Chelmer and Blackwater Navigation Conservation Area. Following separate and independent heritage assessments, both Mr. Carron and Mr. Stoughton are agreed that of the 6 heritage assets, only 3 are likely to be affected by the proposal. The estimated levels of harm and the assets are as follows: conservation area, low level of less than substantial harm; the Fox and Raven Public House, low level of less than substantial harm; and the Miller and Carter Barn, lowest level of less than substantial harm. The robustness of these conclusions is evidenced by the fact that not 1 but 2 independent heritage experts agree on them. The proposal adopts an extensive design response to ensure minimal harm to the heritage assets, and that is clearly witnessed by the fact that the harm to any heritage asset is no more than a low level or less than substantial. However, the custodians disagree on these conclusions. Unfortunately, the extent of their disagreement is still unclear despite their evidence having been presented at some length. There's no assessment of harm for specific heritage assets in Mr. Ford's evidence, nor is there a methodology as to how he alleges harm to designated heritage assets and to what degree. Mr. Ford bases the bulk of his heritage criticisms on the Chelmsford Borough Historic Characterisation Project to allege harm to the conservation area. However, this is an outdated study stretching back to a time before the adaptation of the 2012 MPPF. It does not require the asset-based approach required by the MPPF when assessing harms to heritage assets. Even the conservation area appraisal does not reference this study. There is little to be taken from this study, since this is a broad brush characterisation of the historic landscape. The conservation area appraisal, which looks at the conservation area as an asset, provides more detail, and the appellant's assessment does correctly take into account the appraisal. Prentice's Farm, although the custodians initially raised a concern regarding the lack of consideration of impacts on Prentice's Farm, Mr. Ford in evidence accepted that there is no relationship between the appeal site and Prentice's farmhouse. Rather, Mr. Ford wants to consider the group value, and such value has already been considered by Ms. Stoughton, since she accounts for the dynamic views and historic relationships relevant to the appeal site in her assessment. Prentice's Farm, however, is not an asset which is affected, since it has nothing more than a remote and ephemeral connection to the appeal site. Encroachment. The custodians also wrongly allege harm from encroachment into the water meadows. This is another misunderstanding of the historic character of the appeal site. The site never was part of the water meadows. This is best demonstrated by the historic hedgerow boundary and the geological mapping, which shows the lack of alluvium deposits within the appeal site as opposed to the surrounding floodplain water meadows. The appeal site is different in character. It has been an agricultural field separate from the water meadows. Mr. Ford also accepted that the appeal site is different in character to the water meadows, but argues that it should be protected from its difference. It should be protected for its difference. The corollary of that argument is, no matter what the relationship of the site is to the surroundings, whether the site has significant shared characteristics to the protected heritage assets surrounding it, or it shares none of the characteristics, the site should be protected equally. The proposed bund. The bund will not eradicate the history of the site, nor will it be uncharacteristic of the local area. This is discussed further under flooding. Historic England's comments. Ms. Stoughton, with her 25 years' experience of being a heritage professional and having worked with Historic England on numerous projects in her time, explained that when Historic England object to a proposal, they use the term objection. This is their standard terminology. Therefore, although in this case Historic England do raise concerns about the decision maker, that the decision maker should bear in mind when assessing the proposal, they do not object to the proposal. Contrary to the custodian's assertion, Historic England cannot carry out the paragraph 215 MPPF balance of assessing whether the public benefits of a proposal outweigh any heritage harm. That is strictly a planning balance exercise for the decision maker. What the Historic England response does is to point out that there are no heritage benefits, and the appellant agrees with this assessment. Indeed, Ms. Stoughton clarified that she does not rely on any heritage benefits in her assessment. For all of the above reasons, the heritage assessment of harms is robust, and we say there is no reason to refuse planning permission on the basis of the heritage concerns. Impact on trees, policy DM17. The dispute around removal of trees can be split into two categories: conflict with policy DM17 and harm to the character of the conservation area at the Green Wedge. Addressing the first of those, Ms Hutchinson accepted, contrary to her written evidence, that the third part of policy DM17A does not apply in this case, since this pertains only to preserved trees and there are no such trees present on the appeal site. It has since been clarified that preserved trees are trees with TPA protection. She also accepted that there is no woodland on this appeal site. Ms Hutchinson explained that she had not relied on Part B of policy DM17 in understanding the reason for refusal. Therefore, it can be said the Council only take issue with the first two parts of policy DM17A, which turns on the understanding of what amounts to unacceptable harm and whether removal of trees can be justified by exceptional circumstances. Leaving aside for a moment assertions of harm to the character of the conservation area in the Green Wedge, the only other harm related to trees alleged by the Council and the custodians are that the trees will be removed, and so this must amount to harm giving rise to conflict with DM17A. Such an interpretation of DM17 would mean that preserved trees, i.e. those protected by legislation, could be removed and replaced where there are exceptional circumstances, and this would not amount to a conflict with DM17. Yet the same cannot be said for trees in the conservation area, even though those trees are not protected by TPOs and they do not have any additional arboricultural value by virtue of being a conservation area. The principles of interpretation of the policy are well established and need not be repeated, but one of the tenets of this exercise is ensuring that policies are not read too strictly or exhaustively, and they are interpreted so as to give effect to their purpose. Therefore, as Mr Dixon explained, a reasonable and logical reading of policy DM17A should be that trees within a conservation area can also be removed where there are exceptional circumstances. There clearly are exceptional circumstances in this case because of the extensive planting regime proposed by the appellant and the numerous public benefits, including the provision of affordable housing of the proposed planting. Mr Spooner provides a comparative assessment of the value of the proposed trees and the trees currently on the appeal site by adopting the Cabot methodology, which seeks to measure the amenity value of groups of trees on the appeal site. The trees are measured for their group rather than individual value, since the trees individually are of poor, moderate quality only. However, when taken together, they achieve a group value, which is more notable. Mr Spooner explained that the Cabot methodology ascribes monetary value to the trees, and primary factors it takes into account are visibility of the tree and their relationship to the public realm. Ms Hutchinson did not challenge this methodology, nor did Mr Ford. Mr Spooner relied on the Cabot assessment results to demonstrate that the 32 poor, moderate quality trees that will be removed will be replaced by 198 new trees whose amenity value, when taken together, will be almost 150% of the current trees on the appeal site. Therefore, he concludes that there will not be unacceptable harm to the trees and certainly no conflict with policy DM17, since the proposed planting will compensate and indeed improve the overall amenity value of the group of trees on the appeal site. What is missing in the Council's and custodians' evidence is any such value-based assessment as to what the trees contribute and why the replacement trees and landscaping offered will not sufficiently compensate for this. Ms Hutchinson's key concern is that the removal of the trees will produce an unacceptable detrimental impact on the character of the conservation area, but this allegation cannot go very far because she has not carried out a heritage assessment. It's Mr Carroll who rightly carries out this assessment and concludes, as this statement, that the harm to the conservation area as a result of the proposal, which includes consideration of the landscaping proposed, would at best be a low level of less than substantial harm. This low level of harm cannot be so significant as to give rise to unacceptable harm in conflict with DM17. So, to the harm to the Green Wedge, as to the harm to the Green Wedge, this is dealt with in more detail than the Green Wedge issue. The southern hedgerow boundary. The custodian's key concern on planting is to do with removal of the southern hedgerow and its loss as a historic hedgerow boundary. It's accepted that a significant proportion of this hedgerow will be removed initially, but the appellant is proposing to replace and maintain the same hedgerow boundary following almost the exact same alignment, thereby minimising any long-term impacts. There were also some technical concerns raised by Mrs Hutchinson as to whether it would be feasible to plant such a hedgerow or other planting into the button proposed on the southern boundary. As Mr Williams explained, there is nothing uncharacteristic or technically unfeasible in terms of planting on such buttons, as you can see such buttons along motorways. The custodians also allege that the proposal's landscaping scheme does not meet Part B of Policy DM17. However, the planting scheme offered, which includes the planting of some 198 trees, will sufficiently mitigate any harms to the local landscape in the long term, which is demonstrated by the potential for increase in amenity value of the proposed groups of trees. However, it must be noted that the custodian's position on trees is somewhat puzzling. On the one hand, Mr Ford conceded that if all other things are acceptable and the planting scheme as proposed by the appellant was received, then they would welcome it with open arms. However, what is presumably stopping them from doing this is their fear of the landscape and or heritage impact that will be created by the proposal. What this position betrays is the custodian's inability to separate the alleged harm to the heritage and or landscape from the harm to trees, an error which persists throughout their case and one which can be seen in the council's position on trees as well. Therefore, in terms of an arboricultural concern against the proposal, there is none. Both the council and the custodian's case are concerned about potential landscape and or heritage harm. The former will be addressed as part of the Green Wedge discussion, and the latter has already been dealt with. To the extent any arboricultural impact is alleged, no expert evidence has been produced by either the council or the custodians to challenge Mr Spooner's conclusions. Design standards are adopted in the local plan through policies DM24 and DM26. The appeal site is outside the city centre, however, as Mr Williams emphasised, it's only outside the city centre boundary by about 20 metres. Therefore, although the standards that should be applied are, as a matter of fact, outside the city centre standards, a degree of judgment must be exercised in applying those standards due to the proximity of the appeal site to the city centre. Further, the shape and size of this appeal site is abnormal with unique dimensions. Therefore, creative design is necessary to overcome design challenges, and this was very much emphasised in the pre-application process for this proposal. The corollary of this is that some standards may not be met fully, but there is a requirement to consider if exceptions apply, and in this case, we say they do. When looking at exceptions, you do have to apply discretion, as Mrs Hutchinson accepted. Privacy. Beginning with the plots which fall short of meeting the back-to-back dimensions, the council have raised issues with a number of units. The plots were discussed in detail during the roundtable session, but in summary, Mr Williams explained that opaque glazing will be provided to ensure that privacy of residents will be maintained. Mr Williams considers this to be an acceptable solution because opaque glazing does not automatically mean not enough lighting for a room. Glazing can be chosen and adapted so as to allow sufficient light through whilst protecting residents' privacy. Turning to plots which do not meet back-to-flank dimensions, there are a number of plots again with which the council have raised issues, and these are dealt with in detail in Mr Williams' proof of evidence, and we do not seek to repeat them here. However, in summary, the appellants have offered a mix of opaque glazing and trellis rear garden screening to protect residents' privacy. Mr Williams considers that the design measures are acceptable, having regard to the notes in Appendix B of the design standards. Furthermore, and importantly, Mr Williams clarifies that opaque glazing windows are not mostly being provided for sole windows in habitable rooms, as was suggested by the council. Amenity. The council accepts that all flats have the necessary private amenity space as per the standards. Mr Williams accepts that, applying the outside city boundary standards, some gardens do not meet the adopted standards. However, this is where the judgment and discretion highlighted in the adopted design standards needs to be applied. Firstly, the proximity of the appeal site to the city centre must be considered, since it's just 20 metres away and standard in homes change. Secondly, the appeal site is a unique shape, such that where usually you would be able to adopt perimeter blocks and apply the usual hierarchy of street approach, this was not possible on this particular site. Thirdly, the proposal offers a 300% over provision of open space, with houses being within 60 metres of access to such spaces. And importantly, the proposal is exceeding its open space requirements on site too. In this context, it's clear that the proposal is an exceptional site which, when applying the qualitative judgment as required by Appendix B of the local plan and taking into account mitigation measures offered, meets the design policies in the local plan. Parking, over provision of parking for dwellings must be considered when assessing whether sufficient car parking spaces are provided. This proposal does not, this proposal does over-provide on the number of parking spaces available for each dwelling, having regard to the newly adopted parking standards. Therefore, visitors can use this additional space. To the extent that the custodians are concerned about traffic impacts as a result of insufficientness of parking, no issues have been raised by the local highway authority or the local planning authority on this basis. Highways. There is no highway reason for refusal. The local highway authority and the appellant's highway team are agreed that the highway elements of the proposal are safe and guidance compliant. The only party who has raised this as an issue are the custodians. Their concern is partly to do with traffic generation and capacity, but as it became evident during the inquiry, their principal complaint arises from the fact that they were not consulted on highway proposals and were not provided sufficient information on it. In his written evidence, Mr. Ford went so far as to allege the highway proposals put forward by the appellant and agreed by the FPA are a cover-up operation. The appellant cannot ease any concerns that Mr. Ford may have about the lack of transparency from the council, as that is a matter to be taken up with the council officers. However, so far as the issues he's raised go to technical highway points, the appellant's response is as follows. Chelmer Village Way Crossing. The final design of this crossing, option 9, was arrived at following extensive consultation and working by both the appellant's highway engineers and engineers at the local highway authority. The proposal was then safety audited by an independent organisation. Therefore, to the extent that Mr. Ford is criticising the technical robustness of this crossing, he's produced no expert evidence to corroborate that criticism. He has not carried out his own assessment of the proposed crossing, nor has he produced any safety audit to the contrary, suggesting any issues with it as proposed. Therefore, there is plainly no expert evidence on which Mr. Ford or the custodians can rely on to make a case that the crossing is somehow unsafe and unachievable. The design was arrived at to allow enough time for both cyclists and pedestrians to cross, since the Chelmer Village Way is a relatively broad road, therefore necessitating a solution which allowed both pedestrians to cross without a rush and for the traffic not to be held up. This resulted in the crossing now proposed. As was explained in the opening statement, the highway guidance is not just one document, but is made up of a whole host of guidance documents. When looking at all these documents in the round, as Mr. Geddes does, it is evident that the Chelmer crossing is guidance compliant and safe for the following reasons. A, the crossing has a wide refuge which allows for sufficient space for manoeuvring for both pedestrians and cyclists. B, there are shared facilities on both sides of the highway, making an unsegregated facility such as the crossing more appropriate. And C, the staggered arrangement with guard railing on the central reservation discourages users from using the central reservation as their route. Assessment of capacity. Mr. Ford claims that the transport assessment does not sufficiently measure capacity and trip generation as the proposals changed during the pre-application process, incorporating the option 9 crossing for the Chelmer Village Way. As Mr. Geddes explained, the transport assessment was for a 59 dwelling development, therefore it is only logical to suggest that the 55 dwelling proposal will likely produce lower traffic. Thus, the TA sufficiently captures it not overestimates any impact. This was accepted by the local highway authority, but not by the custodians. With regard to the removal of lane 2 of the exit from the Beeley Link roundabout as a result of the design of the Chelmsford crossing, the custodians query whether there will be an increased traffic, and if this was measured. The capacity of any roundabout is related to the geometry on the approach, entry, and the interaction between vehicles during the circulatory carriageway and the vehicles approaching from their right. Beeley Link has been found to operate well below the maximum capacity thresholds, and the stop line for the crossing is 51 metres from the roundabout exit, which provides sufficient space for stacking. No evidence to the contrary has been submitted to prove that removal of exit lane 2 from Beeley Link will be unsafe or result in unacceptable traffic impacts. Importantly, no further capacity assessment was carried out because none was requested by either the local planning authority, local highway authority, or through the road safety audit. Site entrance and bus stop. The site entrance has been designed in line with LTN 120 guidance, providing sufficient space and setback for the cycleway and visibility. No evidence has been submitted as to why the provision of a bus stop will be unsafe or result in highway impacts, other than to say that there may add complexity. In fact, the provision of a bus stop is a benefit of the proposal as it encourages use of public transport as opposed to private cars. Importantly, similarly to his assertion on harm for trees, Mr. Ford concluded his evidence on highways by saying that in his view, highway harm will be less than substantial and not enough for a reason for refusal in its own right, but goes to the planning balance. The MPPF clearly sets the threshold at unacceptable impact for highway safety impacts to be a reason for refusal. Therefore, in Mr. Ford's own words, there's not enough evidence for highway impact to be a standalone reason for refusal on a highway basis, and the proposal should not be prevented on highway grounds, and there is no proof of unacceptable impact. This aptly demonstrates that the custodian's case on highways is entirely unsubstantiated by any expert evidence, and they are acutely aware of this. Flooding, similar to highways, the only party who raised flooding as an issue are the custodians. Their concern with flooding are twofold: that the sequential tests have not been carried out in good faith, and the flood modelling work that has been done has too many uncertainties, and so the assessment of flood risk is unreliable. Sequential test. The sequential test has been carried out as part of the proposal. This proposal was accepted by the Environment Agency, the local lead flood authority, and the local planning authority. However, the custodians have repeatedly challenged the integrity of this test. Mr. Ford accepts that there is no prescribed method for how sequential tests should be carried out. He has accepted that the decision maker has significant discretion on how to approach sequential testing, which other parties, including even the courts, can disagree with, but cannot dismiss unless the approach has been perverse or Wednesbury unreasonable. In this case, prior to the inquiry, the decision maker was the council, and they had not raised any issues with the sequential testing or required a reassessment. This was despite the custodians having raised concerns with the sequential test as early as 2023, and the 2024 committee report having concluded the sequential test was satisfied. The committee report does not come to this conclusion in one sentence, but lists in detail flooding considerations for the proposal. Neither the EA nor the lead local flood authority have raised any concerns with the methodology of the sequential test either. Mr. Ford's key criticism was that the sequential test aggregates the land on which the housing is proposed and the land area being offered in public ownership, the transferred land, as one proposal. Instead, he essentially argues the proposal should be viewed as only the land at which the housing is proposed, and this housing, he says, can be offered elsewhere. What Mr. Ford fails to grasp is that the sequential test can only be carried out on the proposal that's come forward, not some other hypothetical proposal with only housing and no transfer land. There is a fundamental link between the transfer land and the affordable housing being brought forward since the parcels of land are in single ownership and they are brought forward together as one proposal. They are functionally linked as well by public rights of way. It's entirely a choice for landowners as to what proposals they put forward for a planning application, and in this case the appellant has brought forward the planning application to the appeal side and is offering the transfer land in order to allow the council to realise its aspirations for public open space in this area, which is recognised in the local plan policies and the council's corporate aspirations. Further, Mr Ford makes the case that the custodians would not wish to see formality on this parcel of land, i.e. the transfer of land, which may be the case if the transfer land became public open space or a country park. Regardless of what the custodians would or would not like to see on the transfer land, the fact is the council, who are the public authority, led by representatives of the people of Chelmsford, would like to utilise the transfer land as public open space, and this is an aspiration recognised in the local plan. The transfer of ownership will be crucial to ensure the deliverability of both the public open space and the affordable housing, since they have come forward together as one proposal. Therefore, the residential development enables the offer of the transfer land. However, Mr Ford failed to accept this and contended that transfer land could come forward notwithstanding residential development due to the mere recognition of its status on the local plan, even though he is not aware of any other proposals for the transfer land to come forward in this area. Usually, when consideration of alternatives is being challenged, there is at least an actual alternative proposal to be considered here. There is none, as Mr Ford conceded. Lastly, there were a number of misconceptions in Mr Ford's evidence which must be addressed. First, Mr Ford in his oral evidence attempted to claim that there was a 18.2 hectare site which could accommodate a proposal. This is plainly wrong due to the size of the parcel of land, the proposal needing 30 hectares in total, and also because a significant proportion of that site is allocated for employment as an employment site. Mr Ford accepted that this was an incorrect observation. Secondly, he also conceded that he had not appreciated the recent changes on the PPG, on the requirements for sequential testing, and he had not appreciated the role that surface water played in a sequential test, despite Mr Bennett's proven evidence having dealt with this point. As Mr Bennett explained, the updated PPG no longer requires the sequential test to be carried out, where it can be demonstrated that development will be safe from surface water risk and will not increase flood risk elsewhere, following implementation of the necessary design and mitigation measures. The appellant's flood risk assessment demonstrates this to be the case for the proposal, and Mr Ford accepted that he does not assess surface water flood risk. Therefore, the custodians have failed to grapple with the consequence of the change to the PPG. Namely, although both the sequential test and exception test were carried out by the appellant for this proposal, and these were carried out prior to the recent PPG changes, but the very need for such a test for this proposal has been brought into question as a result of the PPG changes. Thirdly, Mr Ford boldly claimed that an ability to satisfy the sequential test will automatically mean the planning permission cannot be granted. This is fundamentally wrong in law and has been explained in the recent case of Mead. Failure to pass the sequential test is only a material consideration that goes in the overall planning balance and needs to be weighed against other benefits and harms, not a trigger for the refusal of permission. Considering all of the above, no credible case has been made against the sequential test carried out by the appellants in this case, and this should come as no surprise, given that no one other body, the council, the local lead flood authority and the environment agency have raised any issues with the tests carried out. Flood modelling. The custodians do not raise any issues with the actual method of modelling. Their sole criticism is that the data which has been input into the model, both the use of the EA maps and the data collected at the site level, are defective. Thus, they say the inspector should not rely on the flood risk assessment and its conclusions. Beginning with the EA maps, Mr Barker gave evidence at length in his examination in chief about the uncertainties of the EA data and mapping. However, what was most telling about his assertion was Mr Parker's initial hesitation to admit in cross-examination whether this means the inspector should not rely on the EA maps or data. This hesitation was perhaps because Mr. Parker, as an engineer, albeit not a flood engineer, understands that just because there may be uncertainties in data, that does not automatically render the modelling or results unreliable. Mr. Parker did eventually confirm that his view was the inspector should not rely on the EA maps. The problem with this contention is that the EA maps are the starting point for assessing fluvial flood risk, not just in planning applications such as this, but even at strategic planning at the local plan level. This is not to say EA maps are taken as gospel or that they can never be wrong. That is why the EA maps are the starting point, and following this, developers are required to carry out site-specific flood assessments with local data. If any errors or inconsistencies are found in the EA mapping or data as a result of such local level assessments, then there is a formal process through which the EA mapping can be challenged. Mr. Parker admitted that he has not been through this formal process. USER have the EA maps which Mr. Bennett has used to review the flood risk assessment and concluded that the results are sound. The EA maps have been updated very recently in March of this year. This update introduces a new model using existing data and incorporates climate change data to create a more robust data set. The updated maps have been independently verified and checked. No one, that is neither the LPA, the local legal authority, Mr. Bennett or his consultancy, nor Royal Pasconing, have challenged the Environment Agency's maps. The only party that is challenging the maps are the custodians. Anyone is in at liberty to challenge the EA maps, but when the data is from a national organisation like the EA, whose mapping is relied upon by local authorities, engineers, environmental bodies, and even prospective homeowners when carrying out flood risks, to allege unreliability such that planning permission should be refused requires evidence which categorically demonstrates a flaw in mapping. That evidence has clearly not been presented by the custodians. Mr. Parker's insistence on the fact that the EA recognises there may be uncertainties in the modelling is nothing more than to say that there are uncertainties in modelling. Modelling is by its very nature, modelling in its very nature, I should say, will have uncertainties since it is looking to predict what may happen in the future. Whether or not those uncertainties render all the mapping and data and the conclusions unreliable is a separate question, and one which has certainly not been proven by the custodians. Mr. Parker did, in his examination in chief, refer to some 2021 data from a number of gauges which were labelled as suspect in two sources. Mr. Parker has not demonstrated that these particular data points from 2021 were used in the modelling for the appeal site. The data for the site-specific modelling was taken from data sets which are subject to significant quality control. Further, the term suspect can mean a number of things, not just that the data is false. Turning to site-specific modelling, Mr. Bennett confirmed that this modelling was done by Royal Pasconing, and they used more refined data than the EA to carry out this exercise. The additional refinements include topographical data, LiDAR data at 30mm level, any local structures, impacts on flow, updated catchment data, latest rainfall data, and hydrographs. The site-specific modelling is then reviewed by the Environment Agency, who appointed independent body to verify the modelling. Clearly, no issues have been raised either by the EA or the local flood authority or any expert body as to the modelling undertaken. Further, no credible evidence either from a flood engineer or Mr. Parker has been submitted as to why the site-specific modelling cannot be relied upon. Finally, any accusations that not enough time, care, or attention have been spent on the assessment of flooding are baseless. Mr. Bennett explained the appellant has been in discussions with the EA since 2010, more than 10 years before the actual planning application was made, about flood modelling at the appeal site. The current modelling and proposals subject to this inquiry are the third iteration. Flooding at the appeal site. No one at this inquiry, including the appellant, has said that there's been no flooding at the appeal site. A flood risk assessment and sequential and exception tests have been carried out because it has been recognised that parts of the appeal site lie within flood zones 2 and 3. The appellant's case is that any flood risk on the site can be sufficiently mitigated through drainage design and implementation implementation of flood defences, namely a bund in this case. The flood extents at the appeal site show two model scenarios, one in a 30-year event and one in a 100-year event within the bund, without the bund in place. And Mr. Bennett explains the phrase one in a 30-year or one in a 100-year event can be misleading to members of the public, since it suggests that the expert is talking about an event that will only take place once in every 30 or 100 years. However, this is not the case. Those labels are used simply as a measure of probability of that level of flooding occurring per year. Mr. Bennett accepted that we are seeing more 1 in 100-year events recently due to increased rainfall and saturation. An important and notable factor of the flooding at this appeal site is the difference in flood levels shown in the 1 in 30 and 1 in 100-year event. The difference is only 4 centimetres. This is an indication that the floodplain adjoining the appeal site is sufficiently wide and varied in topography that as the floodplain begins to flood, the water depths will increase in different parts of the floodplain, limiting the spread of water up the floodplain. As Mr. Bennett explained, the floodplain is deeper upstream, i.e. to the west of the appeal site, as opposed to downstream. The flood extents shown in Appendix C also measure the flood extent, taking into account climate change. The bund, which is proposed to be the flood defence measure, has been designed to account for the 1 in 30-year event, the 1 in 100-year event, and additional climate change impacts. As for surface water, it's expected to be at shallow levels in any event and can be intercepted by drainage system and with flood exceedance pipes within the bund. Notably, the LFA have raised no objection, no issues. The proposed bund. The bund is proposed to be at a height higher than the 1 in 100-year flood level, ensuring that sufficient height is provided to account for additional climate change impact and to account the expected water displacement to the west of the appeal site. The effect of the proposed bund is to protect the appeal site from fluvial flood, but in doing so, the design also needs to ensure that it does not raise flood risk elsewhere. The hydraulic modelling done shows that the bund does displace water, but this water displacement is restricted to the western edge of the appeal site. This is understandable given the topography of the area where the west of the appeal site is deeper than the eastern end, thereby being able to accommodate more water. More importantly, the modelling shows that the bund does not increase flood risk elsewhere. Therefore, although Ms. Warner had various concerns about the proposal and the impact it may have on her property and indeed the wider area, the modelling demonstrates that this is not the case. She understandably accepted that she could not understand how there would be no adverse effect because she's not an expert. Despite various complaints from the custodians that the bund is uncharacteristic of the area and would not help protect the appeal site, Ms. Warner accepted that to the north of her property, there is a bund in place which protects the housing to the north of the bund. Indeed, her initial idea to protect her own property from flooding was to put in a bund. This only goes to show that bunds are by no means an unusual form of flood defence. There are effective flood defence mechanisms which are natural and easy to construct and maintain and can simultaneously help with landscaping. Just note there's also a reference to a bund to the south of the river that have been built on the land to the south. The bund is likely to be constructed with clay and will contain the necessary foundation and core works to ensure its stability, and these are all matters which can be dealt with at a detailed design stage for the mechanism of conditions. Interested parties can ask to be consulted on applications to discharge conditions, which is very much open to the custodians. Alternative drainage scheme. The fact that Mr. Bennett had produced an alternative drainage scheme, removing the need for infiltration, was presented by the custodians as almost an acceptance that the drainage scheme previously proposed was inadequate. That was clearly not the intention. Mr. Bennett fairly tried to address concerns raised by the custodians, and the purpose of this was only to show that there was an alternative way to design the drainage strategy. It was to demonstrate that any concerns could be further addressed at detailed design stage, not a suggestion that the earlier submitted drainage strategy was poor. Mr. Bennett confirmed also that he does not expect the EA would have any concerns with the alternative strategy since the discharge rates have not changed. In conclusion, there's no credible evidence to suggest either that the flood modelling is flawed or the sequential test virtually has not been carried out correctly. Now, at that point, I deal with Green Wedge, and we've got lots of text in relation to that. I'm going to skip over that. It can be read in due course. I'll turn to planning balance.
So are you coming back to Green Wedge?
No, I'm not going to read it out. So I'm just going to save time and not read it out.
Okay.
That's just have to make a choice on what to read and what not to read.
Okay.
Planning balance, transfer land. A significant proportion of this inquiry has involved discussing the lawfulness of the offer of the transfer land by the appellant. The key point that users should bear in mind is that the proposal in front of you includes both the appeal site and the transfer land. It's ultimately a choice of the appellant what proposals they put forward, and you can then determine whether those proposals have sufficient planning merits and are lawful. There is no reason why the transfer land cannot lawfully be offered as part of the proposal, since this offer meets the Regulation 122 tests. It is part of the Council's long-held corporate aspirations that public open space, i.e. the country park, be delivered on the transfer land. This is evidenced by the fact the land is allocated in the local plan as future recreation sites. One of the key constraints identified by the Council for this transfer land is under management, and transfer of this land to public ownership will allow the Council to carry out the management works necessary. There is nothing, there is nothing odd about the size of the transfer land, since it is not unusual for developers to provide more public open space than may be required under the local plan policy. Although Mr. Ford may think that is only a handful of square metres should be provided for such developments, the choice is ultimately the inspectors to put forward the proposal they would like. In terms of self-compliance and why the transfer land obligations would meet the regulations, these have already been set out in the self-compliance statement, and so will not be repeated here. Planning balance. The starting point when assessing planning applications is always the local plan. In this case, Mr. Dixon fairly accepted that there is non-compliance with the local plan, namely a partial conflict with DM7, i.e. the proposal is not of the types of development permitted by policy DM7. Therefore, the next step for you, sir, is to determine whether there are any material considerations which apply and outweigh any conflict with the local plan. The key material consideration is paragraph 11D of the MPPN, and the Council and the appellant agree that this applies here due to the lack of private land supply position for 3.83 years. There has been some discussion at this inquiry as to what this actually means, especially in the context of the Council's planning witness has attached substantial weight to conflict with the most important policies, even though they are accepted as being out of date. As a reminder, in the Supreme Court case of Suffolk Coastal, Lord Gill observed that amongst the obvious constraints on housing development are development plan policies for the preservation of the greenbelt and environmental and amenity policies and designations such as those referred to in footnote 9 of paragraph 14. The rigid enforcement of such policies may prevent a planning authority from meeting its requirement to provide a 5-year supply. Paragraph 83. If a planning authority who was in default of the requirements of a 5-year supply were to continue to apply its environmental and amenity policies with full rigour, the objective of the framework could be frustrated. The purpose of paragraph 49, that's obviously the 2012 version, is to indicate a way in which the lack of a 5-year supply of sites can be put forward. It is reasonable for the guidance to suggest that in such cases, the development plan policies for the supply of housing, however recent they may be, should be considered as being up to date. Can I just add, paragraph 49 was relevant policies for the supply of housing. That was the phrase. The Secretary of State agreed with my clients in that case, pursued the litigation on that basis. When the Supreme Court defined it narrowly to mean just housing cases, what do I mean by that? In the High Court, I'll just explain Secretary of State's decision, but the new NPPF came out in 2018, 6 months later, and didn't use the phrase relevant policies for the supply of housing. He used the phrase most important policies for determining the planning application. Why is that important? Because the inspector granted planning permission was challenged in the High Court. The Secretary of State defended at that level, but then didn't defend the inspector any further when the case went against them. My clients appealed to the Court of Appeal. The Court of Appeal, Lord Justice Sullivan, granted permission to appeal. The Secretary of State then rejoined and then defended in the same position adopted by Richmond Estates, and then the matter was joined with Hopkins. It went to the Supreme Court. The point being, the Secretary of State pursued the broad definition. When that definition was rejected, so housing policies having a broad definition, when the Supreme Court rejected that definition, 6 months later, the politicians in government decided to adopt the broad definition anyway. That's why you have the definition from 2018 that follows the argument that Richmond Estates and the Secretary of State made and Hopkins made in that case. What is astounding in this case is that the Council are defending the position that it's entirely logical to ascribe substantial weight to conflict with out-of-date policies on the basis that it is a matter for the decision-maker how much weight policies should get. The weight has been reduced from full weight to substantial weight, and these policies should receive substantial weight as they are compliant with the NPPF. We agree with the first proposition. It is indeed a matter for the decision-maker how much weight to give a policy conflict, even for those policies which are deemed to be out of date. However, if we may if we were to pray any heed to the words of Lord Gill of the Supreme Court, local authorities simply cannot continue to apply their out-of-date policies, especially those which restrict housing, i.e. the green wedge policies, with full rigour. The Council may say that that is not what they're doing, since they have reduced the weight from full to substantial. I think I said yesterday significant, but forgetting, of course, Mrs. Hutchinson's position is they still give them substantial weight. However, this marginal reduction is essentially an application of full rigour of those policies. No explanation has been provided as to how the so-called reduction in weight has any impact at all on how the Council weighs its policies, and this is especially troubling since Mrs. Hutchinson's first confirmed in her evidence that substantial weight was the highest order of weight that had been given, but then ultimately changed her highest order of weight to full weight. I mean, in short, none of this makes even remote sense. Before diving into the balancing exercise, it must also be noted that the Council and the appellant are agreed that public benefits do outweigh any heritage harm, so there are no reasons to disapply the tilted balance. However, the custodians through Mr. Ford have changed their position on this. Harms, starting with the harms of the proposal, below is a table summarising the appellants, the councils and the custodians' weights of harm. The appellant says that only limited weight should be given to conflict with DM7, since it is only a partial conflict and because the policy is out of date, and so they must be reduced weight. Although generally great weight should be given to the preservation of heritage assets, in this case the heritage harm only attracts limited weight, since the level of harm is highly restricted at low and very low levels of less than substantial harm. The interpretation of policy DM17 has already been discussed under the issue of trees. As to weight, the appellant's position is that there is no policy conflict with DM17 due to the interpretation of policy DM17, namely that there is no unacceptable harm to the trees due to the amenity value to be replaced, and that there are clearly exceptional circumstances that outweigh any removal of trees, explained further under benefits. Mrs. Hutchinson counts conflict with the local plan as a whole as a separate harm, This is plainly double counting, it should be double counting, since local plan policies incorporated within the harms and benefits proposal, and Mrs. Hutchinson accepts this. Therefore, no explanation has been given as to why policy conflict and harm get two weights, even though they are both addressing the same issue. Mr. Ford and Mrs. Dixon agree that this would be double counting. The benefits, and we provide the weighting there. Disaggregation is important when carrying out planning balance exercise, since it clarifies what weight is being applied to what benefit and harm. In this case, there is a disaggregation in the housing benefit by both Mr. Dixon and Mrs. Hutchinson, and this is because the council's failure to have a private land supply, which this proposal will address. At the time planning application was made, there was no statutory requirement for 10% BNG, biodiversity net gain. Therefore, this proposal, providing 10.25% for habitat gain and 63.86% gain for hedgerow units, should be given moderate weight. Affordable housing, for clarity, has been given the highest weight by both Mrs. Hutchinson and Mr. Dixon. This comes as no surprise given the phenomenal levels of affordable housing crisis faced by the council. Mr. Stacey's evidence sets out the numbers of key statistics, some of which are as follows. Chelmsford has already accumulated an affordable housing supply shortfall of 78% over the last 2 years. It has a median house price to income ratio is 27% above the national average. Its lower quartile house price to income ratio is 43% above the national average. The average wait times for housing for those on the register range between 11.3 months and 33.8 months. Of 435 households in temporary accommodation, as of March 2024, 67% were households with children. The council queried in their opening as to why the appellant has decided to bring an affordable housing expert to give evidence to this inquiry when they agree that affordable housing should be given the highest weight. The answer is simple. The very fact that we are at this inquiry, where 100% affordable housing scheme proposals come forward, almost a decade of working having gone into it, being rigorously assessed by council officers and finally securing a recommendation for approval, only to be refused by the planning committee. It's not enough for the council to simply say they give affordable housing the highest level of weight. The statistics above are not just numbers, they are actual households struggling for a home behind it, and they need to be represented at appeals like this. The custodians have split the weight they give to affordable housing, favouring affordable rent to shared ownership on the basis that the council's needs are primarily affordable rent homes rather than shared ownership. The proposal has a 10-year split of 44% affordable rent and 56% shared ownership. This 10-year mix was arrived at following conversations with the council, which is evidenced in both committee reports. As was explored with Mr. Stacey in his evidence, policy DM2 does require provision of the mix, size, type and cost of affordable housing to meet local area needs, as reported in the current strategic housing needs assessment. The most recent CRHnews does not set any specific requirements, but instead asks the council to take into account local needs and viability assessments. Therefore, there is no conflict with policy DM2. In fact, as Mr. Stacey explained, the proposal exceeds the current policy requirements for affordable housing by providing 2 additional affordable rent homes and 24 additional shared ownership homes. The tilted balance requires planning permission should be granted unless any adverse effects would significantly and demonstrably outweigh the benefits of the proposal, having regard to the NPPF as a whole. However, it does not stop there. The latest NPPF requires specific regard to be had to key policies which direct developments to sustainable locations, making effective use of land, securing well-designed places, and providing affordable homes, individually or in combination. In this case, the proposal is clearly in a sustainable location, with its location adjacent to the city centre. It seeks to make effective use of land by providing a suitable density of dwellings along with public open space, and most importantly, it's a proposal which provides 100% affordable dwelling scheme. The council will no doubt say, but what about well-designed places? It should, and they did. It should not be forgotten that design of dwellings and scheme was reviewed and considered by the council officers and were recommended approval. It should also not be forgotten that the proposal went through a lengthy pre-application process with several discussions and iterations of design to ensure that the most effective and satisfactory design was achieved. Therefore, this is not a case where the appellant is offering a poorly thought out design for affordable housing. To the contrary, the appellant has been open and engaging with the council through the pre-application process, and the lead-up to the application design was accepted by the council's officers. To go further, Mr Williams, as set out above, provides detailed explanations as to how the proposal does meet design standards and is acceptable, and emphasises the need to exercise a degree of judgment having regard to the circumstances of the proposal. Therefore, the proposal meets the requirements for well-designed places as much as it meets other priorities under paragraph 11 of the NPPF. And having regard to the harms and benefits in the table set out, we say that it is the benefits of this proposal which significantly and demonstrably outweigh the harms. Therefore, in conclusion, we ask you to allow the appeal and grant planning permission. If I may just spend a couple of minutes finally dealing with some of the points that were raised.
Okay.
I'm obviously not going to deal with every point, that won't be of assistance to you. Paragraph 85, starting with the custodians and Mr Ford, it's an example of where we get in parenthesis or in brackets in reference to the information has been deliberately withheld. All I would say, that's on page 30, if you have that, that's page 30, 85.
Thank you. Yeah.
All I would say is it's unfortunate that these type of comments are made, but in any event, we've been here in a public inquiry where everything has been scrutinised to the nth degree, so nobody could really legitimately complain. They may complain about not seeing everything or every conversation, but the planning system cannot operate to allow third parties to interfere in every decision and every meeting and every bit of correspondence between professional officers and an applicant. It wouldn't work, and it's an excessive requirement. Indeed, freedom of information requests are arguably an excessive requirement and bring a great deal of difficulty to local authorities and other organisations, but at the very least, all matters have been discussed here which are relevant to the substance of the case. And paragraph 90, we see in a similar theme, this suggestion that the local authority have been influenced by the gift. It's added with the word perhaps. Really, really unfortunate. In a country such as ours, where the integrity of public officials is of absolute paramount importance to the decision-making process, that accusations such as this against public officials are made by virtue of closing submissions or letters or correspondence. There is absolutely no evidence at all of that influence. And in any event, the officers, while they recommended approval on the basis of the evidence before them, set out a 54-page reasoned report, the members still refused. But where does that actually take the custodian's case to just liberally accuse people of what is nothing short of unfortunate accusations of inappropriate influence? Paragraph 130 is the issue about how often flooding has occurred.
Sorry, 130?
Yeah, 113.
113, yeah.
And what's important to realise is that events can happen in the 1 in 30 year and 1 in 100 year event more frequently than, as Mr. Bennett has explained in our own closing. It doesn't mean once in every 100 years, it means the frequency of when it's likely to happen, and it can happen more frequently in 1 year in any event. And here we're talking about over the course of 6 years. And all of that, actually, the increased propensity for rain and heavy rain is factored into the climate change component of flood risk analysis. paragraph 118, suggesting that the EA's model is therefore constructed on the basis of inaccurate data. But that there is nothing to suggest that the EA has used a model based on inaccurate data. There is a process for challenging it. You have to, I would respectfully suggest, rely on that modelling until such time as there is a conclusion by the EA with all the data that's available to them that somehow that is wrong. Saying there are frailties with monitoring stations, it does not come close to demonstrating that the model is inaccurate. It is clutching at straws. There's reference to Mrs. Warner's evidence from sort of 121 onwards. As is made clear in the closing submissions, she is not an expert. She and her husband live in the mill, which they have successfully avoided being flooded in all the time they lived there, in what is a very wide floodplain. Even though for the purpose of the mill they have to elevate the height of the water, so it operates as a, well, that used to operate as a mill. And for the reasons that are explained by Mr. Bennett, there is no increased risk of flooding as a result of the site because of the depth of the water increasing behind the bund on its western side. But it's important to recognise that a lot of the flooding that is happening where they are and further south is a result of the A12 dam, in effect, which is what Mr. Parker calls it. He readily, you'll remember, readily accepted that and acknowledged that in questions I put to Mrs. Warner, joining in, but it wasn't unhelpful. And if there is a long-term problem here, if there is an issue of climate change in future years, over the next 30, 50, 100 years, that is the absolute solution, which is to release the damming of water by the A12. It's not for my clients to provide that solution because the modelling has been accepted. But if anybody has concerns about the position of the long term, that is certainly something that would warrant investigation. Paragraph 131 is suggested that on Mr. Bennett's case alone, the pushback by the bund is not zero, and this would categorically increase flood risk. No, and categorically no, and his evidence was clear on that. Okay, there is no increase in flood risk elsewhere, and the acid test of that is the Environment Agency had to be satisfied. That's their test. It's a test in the NPPF as well. The Environment Agency were completely satisfied that there would be no increased flood risk elsewhere. And in a floodplain, I mean, that literally means not any quantity of water where there'd be an increased risk, and they were satisfied with that. Except we just do not know, implicit, this is the redesign, implicit design, there's an acceptable solution. However, there are several other alternative solutions, and that is an appropriate way to deal with the matter. It is not about throwing every possible piece of mud at this scheme and hoping it sticks. If there are solutions to problems achievable through alternative solutions that can be the subject of conditions, that is the way in which planning applications and appeals should progress. All the parties should cooperate. The council have been cooperative on that point. When I say so, what the officer said yesterday was absolutely on the point, which is that why would you not look at alternative solutions that may provide a better solution, and it will be for the local authority to approve it. That, I think, is all the points in relation to the custodians. Just I've gone over a little bit, just briefly, if you're happy to say just 5 more minutes.
Yeah, go. That's fine.
Okay, just generally on the value landscape issue, so there's reference to the CG case, for those wondering what that means. CG is a developer, and they lost an appeal, and they went to the High Court, and as is characteristic of about 95% of High Court challenges, it failed. Against inspectors' decisions, it failed, because the courts repeatedly say it's a matter of judgment, not just on as the lead at Redrow on things like sequential testing, it's up to the decision maker. The same with value landscape. The conclusion you reach it is entirely within your discretion, and the courts will support that. I note with interest that the travelling showman side inspector did conclude that it was a value landscape, but still allowed the appeal. So it's not an embargo, but you obviously need to look at the need to protect and enhance. I would suggest, though, that the obvious position in this case is that it's not a value landscape for 3 main reasons. First of all, the council did not for 1 minute think it was a value landscape throughout the application process and throughout the start of the appeal process. Secondly, the only reason Mrs. Hutchinson thought that this was a point that she could argue was because she saw another appeal decision and thought we could adopt the same reasoning. I mean, that's not going out and doing an assessment, that's just going, oh, there's an appeal decision, perhaps we can run that argument. And the third point, and the most important point, is that if you are going to venture into this, you'll need robust evidence, which is precisely the point the local plan inspector made, and which the council have failed to provide. The council have still failed to provide that. Mrs. Hutchinson's attempts to talk about the wider area being a value landscape are at best tentative, and she doesn't really address the appeal side anyway. And that is not robust evidence. The robust evidence, which Mr. Williams referred to, was the evidence on our side. We've got the evidence, and he reaches the conclusion it's not a value landscape. It's flying a kite, it's been very unfortunate, it's wasted a lot of time. Councils really should reflect on the credibility of raising back points at a late stage, whether it was done, well, I don't know, I'm not going to speculate, but it was a very disappointing and unfortunate thing, because otherwise we have to start saying, well, statements of common ground aren't really worth the paper they're written on. That was the CG case. It's a matter for you how you approach it, but what I would say is that even if you say that the Chelmer Valley East has the characteristics of a value landscape because it's out of the ordinary, even if you say that, nothing prevents you from saying that you don't think the appeal site exhibits the characteristics of the Chelmer Valley East river area as a whole. And what makes it particularly likely, in my submission, that you might reach that conclusion is that this is absolutely on the edge of it, visually separated by it, and not actually part of the flood meadows or the fluvial floodplain, but actually the expanse of what people call the water meadows. I think it's not always water meadows. It is very obviously distinct. Just a few other quick points. Paragraph 20 is Mr. Callan's valiant attempts to take a plan that hasn't even been the subject of full consultation, let alone examination, and elevate it on the basis, well, the green wedge is in there now, and the green wedge is going to be in that plan in the future. We have no idea what will happen through the objections. What we do know is that the council will have to find more housing sites. A lot of the area around Chelmsford is green wedge, and green wedges are locations where new development may well have to take place. That's what we know. Anything else is conjecture. You could give any limited weight, which is precisely what Mr. Dixon does. And indeed, Mrs. Hutchinson, it's difficult to know where that guide is headed to. Paragraph 21, Mrs. Hutchinson's approach to reduce the weight of these policies on account of the absence of the 5-in-1 supply, but by one category only, is the right approach. Well, there's nothing wrong with having a little bit of confidence about your case, but to suggest to you that that's the right approach just flies in the face of everything that Lord Gill says. And as has been pointed out in our closing submission, substantial weight was her highest rating until she ran into this difficulty. And therein lies the problem with this whole case. The council, through its witness, didn't really reduce any weight to the green wedge policies, or indeed any policies, and therefore approached the case as if the 5-in-1 supply were just a mere irritation. Paragraph 24, we highlighted the affordable housing, they highlighted the well-designed places, just for the avoidance of doubt. All of the 4 additional factors highlighted would carry equal importance. There's no contest that in that sense. It's just when you're dealing with affordable housing, then that is obviously going to be a central focus. Paragraph 40 deals with the planting, suggesting it was just because it's on motorways it would be fine. Mr. Spooner gave agricultural evidence on this, and what Mr. Williams said was more extensive than that. Paragraph 44, this is the note that was put in. Mr. Cannon didn't provide the note until after cross-examination. I always find that a little disappointing, if I'm honest. Mr. Williams had it in front of him. I didn't, but I've read it. Mr. Williams' advice to me, read the whole thing really carefully. The role that the planners would play is having been informed by appraisal work done by the experts. Of course, planners, like you, need to interpret the evidence, but you need to have the evidence in the first place. It's not a case of saying, well, planners are now the people to do all the landscape visual assessment work. Paragraph 53, reference to the trees. We've covered this in closing, but please do look at that part of the policy which specifically refers to replacement trees. It's specifically highlighted within the policy itself. There's a reference to the affordable housing at one point, and what it says is it makes a modest contribution. I can't quite find the paragraph number for that. It makes a modest contribution to the affordable housing need. Well, isn't that the truth? It isn't the sheer scale of unmet need and this council's complete failure to address its own identified needs, the reason why it's modest. The scale of the problem isn't a mitigating factor for the council's complete inability to meet the needs of its own people. It's an aggravating factor. For the 55 households that will move into these houses under appropriate tenancy arrangements or shared ownership, it will be life-changing. But you're right, a great deal more land will be needed because it is only a modest contribution given the enormity of the council's problems. They were lauded as the best in Essex, one of the highest in the country. Many local authorities in this area have largely abandoned plan making, and the level of unmet need in Essex is absolutely colossal. Finally then, please, paragraph 76. It suggested it would be impossible to outweigh the harms because of the harm to the heritage balance, and an attempt to allow the Rule 6 party on heritage to be, they may wish to make more of this. In other words, perhaps we as the council, Mr. Trent, perhaps we should have kept our heritage reason for refusal and at least consider what the Rule 6 party might like to do if they would run with the ball as well. This proposal on a flat balance could outweigh the harms of the development plan, and any advocate who thinks that's impossible just doesn't understand how it works. You obviously can outweigh harm with benefits. And that is what the courts say when they give you, the decision maker, almost complete discretion as to how you apply that. We don't need the tilted balance to win, but with the tilted balance, the conclusion here is obvious. Unless I can assist you further, those are all solutions.